Right, Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. Right, so today we are going to discuss the new topic, which is the law of thought. Right, so in this topic is very important, right? Because if you study law without the law of thought, it is not complete. So because the law of tort is one of the branches under the private laws. You have learned about the contract, okay? You have learned a little bit about the criminal law, right? So as you know that the criminal law is a relationship between the individual and the state. The contract is more on the relationship between the parties to the contract, right? But for the law of tort, it is under the civil law, right? But it is a little bit in terms of coverage is it is wider than the law of contract, right? So to some extent there is no contract at all in the law of tort. Of course, there is no contract, right? It is more on the rights of the individual against the other. All right. Okay. Okay. What is tort? Okay. Firstly, what is tort? Tort is actually it's a Latin word, which means wrong. Eh? If you realize that many terms in the law, they actually derive from the Latin words. So one of the that terms is a tort, T-O-R-T. It is very rare for those who have not learned law. They will not find come across of these terms, tort. Okay, so it is basically is a law of wrong, law of wrong. But this is related to the civil wrong, not the criminal one. Okay. That's why it says that the wrongdoing is done as against the other's right or interest. The other's right or interest. So I highlight here, the other's rights and interests. Okay. So example of types of civil wrong is assault, battery or trespass, and etc. Okay, so this is example three example of tort, the civil wrong. Okay, so according to Winfield, it is Winfield says that the tortious liability arises from the breach of the duty primarily fixed by law. So this duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. Okay, if you when we study the law of contract, so we have come across all these terms like breach of duty, breach of contract, right? So under this tort, law of tort is more on a breach of duty of care. So that duty must be fixed by the law, not by the contract. Okay, because there's no contract at all. The law itself has impliedly say uh, impliedly put in the duties. So the duties is not fixed by the parties. Okay, the duties are not fixed by the parties, but instead by the law. So who's the law? The law is actually those principles developed by the most of the time is developed by the court. In case of the law of tort, it is developed by the judges, by the decision of the judges. Okay, so that is how the law of tort comes about. Okay, so under the law of tort, a suit where a purpose of legal action is to obtain private civil remedy. So the objective of the legal action under the law of tort is to obtain a private civil remedy, not to compensate, as compared to the. So later on we will compare how torts is comparable with contract and also the criminal law, right? Okay. So such as damages, so this is remedies of the law of tort. Okay, right. If the criminal law, usually we want to punish the criminals, but under the law of tort it's actually not to punish but rather to get or to obtain private rights, okay. So under the law of tort, the claimant must show that they have suffered foreseeable loss, the word foreseeable, so that loss must be foreseeable, because some loss are not foreseeable, some losses are not foreseeable. Example like earthquake, we call it the God's act, it's not foreseeable. So under the law of tort, that loss must be foreseeable. Okay, foreseeable by who? Either by the defendant, okay, or by any persons, any reasonable persons. Okay, losses or harms as a direct result of the breach of duty. Okay. So another example of the law of torts, under the law of tort, example like negligence, example, so we're talking about negligence like road accidents, negligence made by the doctor, okay, libels, okay, or defamations, they say you make wrong statements, wrong statements against others in the newspaper, so that is we call as libel, or defamations, okay. When you are arrested by somebody or by the police, not only the police but the other persons, you are arrested and put in the confined space, in the and so that is as a that is your rights, as a civil rights. You can actually, under the civil right, you can actually sue that person under the law of tort, another example like trespass, when somebody trespass your land, okay, so that is also considered as a under the law of tort, so all in all, under the law of tort, there is a kind of in terms of particularly in terms of the remedies, is a more or less like any contract, it's a more or less like contract whereby you can get some kind of remedies like damages, okay. But to some extent is in terms of type of the nature of the wrongdoings, it is more or less like criminal law, so it is kind of hybrids between the criminal law and the tort, sorry, and the contract, under the law of tort. It's a hybrid, because in terms of damages, in terms of remedies, it's more or less like contract, but in terms of nature of the wrongdoings, it's more or less like criminal law. That's why in the sometime, uh, an offense or an act can be regarded under the criminal law as well as under the law of tort. Example, like defamations. If somebody writes a wrong statement against you, okay, you can actually sue that person, okay, if you feel that that statement is not right, well, and you, of course, when the statement is made, you becomes your reputations, in terms of your reputation affected by that kind of statement. Of course, you are very shy, and then so you can sue that person under the law of tort, but at the same time you also can actually make a report to the police, under the criminal law. Okay, so it's more or less like a double actions lah. But this is not this kind of act is actually not covers all lah, not all nature of offense can be both tort and the crimes. Example like in road accidents. Road accident normally, if not involved in the deaths or any negligence, is only civil. But if involved fatal accidents which caused by one of the parties, you can be that persons, okay, that driver uh, can be indicted or can be charged under the criminal law. Okay, but most of the time in road accidents which involve very small injuries, something like that, it is just involved under the civil. Okay, right. So the person who commits the act is called tortfeasor. The person who made that wrongdoing, okay, in other words, is called a tortfeasor. Okay. Okay, right. So now we try to compare between tort and contract. Okay. So under the law of tort, duties of the parties are fixed by law. Okay. Whereas under the contract, duties of parties are based on the agreement fixed by the parties themselves, right? So what is meant by fixed by law? Fixed by law, as I said just now, means that the 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 law itself has actually laid down that the principles, not the parties. Okay, example like when the case is brought to the court, the judge himself will actually will decides based on the law, with a principle of law. Normally the tort actually based on the cases, based on the cases, decided cases, principle made by the judges. You still remember sources of law? So sources of law, one of the sources of law is unwritten, right? Whereas we unwritten, we do have judicial precedents, right? We do have English rules of equity and common law, and that is a principle developed by the judges, right? Okay, not through the statute, right? Okay, so under the contract, of course, the duties are fixed by the parties in the agreement, right? So though under the law of contract, of course, the parties have to refer to the Contract Act 1950, but in a way that the Contract Act actually are more flexible in terms of the contents of the agreements. So whatever agreements, as long as it is not against the law of contract, then the law actually uh, permits some agreements and some terms in the agreements and terms in agreement. So they are actually are more flexible in terms of the what are duties under the law of contract as compared to the tort. So the purpose of the remedy for under the law of tort is to restore the position of the plaintiff to the position before the commission of tort, right? Right. So normally, the one of the famous of one of the common damages, common remedies for the law of tort is damages. So the objective is to restore status quo, to as if there is no what you call it, there is no wrongdoing is made. So as compared to contract, the objective or damage is to the damages is to compensate the plaintiff as if the contract would have been implemented. Okay, so in the tort, as if there is no tort, as if there is no wrongdoing, to put the parties, especially the plaintiff, in the original positions. But the contract is to compensate. Okay, to compensate the plaintiff, as if the contract would have been implemented. So there is difference. But what is the similarity between tort and contract? Both are under the civil. Okay, so we need to say there is no such interference of the from the state. Right. Now, the difference between tort and crimes. So when talking about tort, of course, is a civil wrong. Okay, between civil and civilians. Okay, but the crimes is criminal offences which against the state. Okay, and under the tort, of course, when talking about the civil wrong, the person or the defendant is being sued between plaintiff and the defendant, right? As compared to the crime is between the prosecutor and the versus defendant or accused person. Okay, so the term is also different under the tort. Under the tort is we use the term damages when the plaintiff uh, want to sue and get that kind of remedy, we call as a damages. But the crime we don't call as damages, punishment. So the term is punishment. When a criminal is convicted, then he or she will be punished. We don't use the word punish in the tort or contract. But in the crime we do use the word punish upon conviction. Again, as far as the burden of proof is concerned, under the tort, since it's civil, same goes to the contract. The burden of proof is just balance of probabilities. As compared to the crime, burden of proof is beyond reasonable doubt. Okay, so balance of probabilities means meaning to say in terms of weightage, weightage of proving the case is more or less the level standard of burden of proof is lower than the crime. Okay, to some extent, if there is a doubt, it's still okay. But for crime, if there is a reasonable doubt, right? If there is a reasonable doubt, the defendant is to be acquitted, and released and acquitted. Okay, but there must be a reasonable doubt lah, of course. Eh? So that's why it says beyond reasonable doubt, meaning to say there is nothing reasonable at all. Eh? So in crimes, normally it's easier for the defendant actually to actually not to create lah, I would say to raise a reasonable doubt, to raise a reasonable doubt as compared to the prosecutor. Prosecutor will do very tough job, whereas uh, the prosecutor has to prove that there is no doubt at all, there is no reasonable doubt at all. Otherwise, the case will be the defendant will be acquitted, right? Right. So I think you are able to differentiate between tort and crime, as well as tort and contract. Right. So when talking about a law of tort, okay, when talking about law of tort, uh, we must not actually we cannot avoid to discuss the principle of negligence, the principle of negligence, because in order for a tort to be proved in the court, right, the plaintiff must show to the court that there is a negligence, there is a negligence committed by the defendant, right? Otherwise, uh, the plaintiff cannot succeed in the case. So what is negligence? So negligence is defined as a breach of legal duty, to take care which result in damage undesired by the defendant to the plaintiff. So the keyword here is the legal duty, the legal duty, right? Or the duty of care. Right? That's why under the negligence, under the principle of negligence, there are three main principles or ingredients that the plaintiff must prove, must show in the court that there are three ingredients under the negligence. Okay, one is duty of care, the legal duty or duty of care. Okay, so the plaintiff must show to the court that the defendant has a duty of care towards him. One. Okay. So second part is based on that duty, the plaintiff has to prove that the defendant has breached that duty. Okay. The defendant has breached that duty. So it is not only that the defendant has a duty of care, but in fact he has breached the duty. So that is the second ingredient. And the third is upon breaching that duty, right, there is a damage. There is a damage on the part of plaintiff. Okay, there is a damage to the plaintiff. So if these three ingredients are fulfilled, then the plaintiff may succeed in the case. Otherwise, it's very hard for the plaintiff to win the case. Right? Okay. Right. Okay. Right. This is more details. Duty of care. Let okay. Not all act done carelessly by the person will compel the person is within law. The person only liable in negligence if he is under a legal duty to take care. Right. So how to determine the duty of care? Right. We need to say what is the parameter used by the court whether a person has a duty of care or not. It is decided under the case of Donoghue and Stevenson's. So this case is very very famous. It lays down the principle of neighbors principle. The neighbor principle. So the neighbor principle is uh, actually explains eh, explains the principle of duty of care. Okay, the neighbor principles. So under this neighbor principles, in this case, Lord Atkin is the judge in this case. He developed the rule whereby under eh, under this case, he says that the rule that you are to love your neighbors becomes in law. He says he's using the word is term metaphor. In this case. So what is the neighbor principle then? You must not injure your neighbor. And the lawyer's questions, who is my neighbor? Right? Receiver receives reply. You must take reasonable care to avoid act or omissions. Act or omissions which you can reasonably foresee. Another keyword here would be likely to injure your neighbor. Okay. So the word neighbor here is not actually physical neighbor. It is more on the others' rights, other person's rights. It's not physical neighbor. It is not your neighbor. It can be your neighbor, of course, but it is not actually. It's not actually necessarily your physical neighbor. It can be either person far away from your house. It can be person in England, for example. In person in uh, which are very remote from you, but still your neighbor. So the character of neighbor is that you must you have a reasonable care to avoid act or omissions. And the word act or omissions, and which you can also reasonable that duty must be reasonable foreseeable. Reasonable foreseeable. Okay, if the act or omissions must be reasonably foresee, would like to injure your neighbor. Okay, right. Okay, so what is neighbor against? So the judge actually explained that neighbor, those person who are closely and directly affected by my act. Okay, closely is not also physical in nature. Can be it, that person may be far away from you and directly affected by my act. Okay, that I ought as ability to have been there in contemplation as being so affected and directing by. Okay, questions. So I think that you still not understand the terms neighbor here, but I would give you to give clearer picture on this. Let's look to what happened in this case. Donoghue and Stevenson. So to clarify the terms duty of care. So in this case, what happened in this case is that a manufacturer of ginger beer, so it's kind of drink, in this case, had sold to a retailer, ginger beer in an opaque bottle, in a bottle, in opaque means not transparent, So the retailer resold it to A, who treated her friend to its content. So we need to say from the manufacturer to a retailer, from a retailer to a friends, right? From a manufacturer to a retailer, from a retailer to to person called A, eh, which who treated her friend to its contents. So we need to say, in this case, the in terms of that individual that who was affected by the defendant's act is in terms of physical is very remote, right? But what the court say about this? Okay, so when the ginger beer bottle was actually the ginger beer bottle that being treated by is A has decomposed remains of a snail. So there is a actually uh, there is a manufacturing defect here, where is there is a snail, decomposed of snail, not the snail, decomposed of remains of snail, which is dead already lah. So A's friend alleged to become seriously ill. Maybe uh, she was terrified, when shocked and terrified when looking at the decomposed snail there. Of course, when you want to drink, right, and then you see something in your drink, of course you shock, right? So in this case, the plaintiff was very becomes ill. She becomes ill, became ill, and as a result of that incident. So in this case, the court held that although there was no contractual duty on the part of the manufacturer towards his friend, right? Maybe that contract only between uh, ginger beer manufacturer and also and the retailer. The manufacturer owed the duty of care, to his friend, and the bottle do not contain any noxious matter. Noxious is harmful, harmful matter, and he would be liable if the duty was broken. Thus, the plaintiff was entitled to recover damages against the manufacturer in negligence. Okay, any person who manufactures product in such a way that there is no reasonable possibility of intermediate examination before they reach the ultimate consumer. So, in other words, an example of duty of care or in negligence, in terms of manufacturing company, whether it's a food or drink, right? So they have a duty of care that the product must be must be safe, must be safe, and it must be safe and doesn't make any uh, make others problem lah, others because in this case, like, doesn't make people ill lah, people sick when consuming their product. Okay, so when looking at this case, you can make an other analogy to other manufacturing cases lah. So this case also can actually extend to another cases of manufacturing uh, producers, that they have a duty of care, duty of care that their products are safe, to be, especially to be consumed, if you drink and food, of course, safe for the to be consumed by the consumers. Okay, that is meant by duty of care, right?